was trying to use the law library in the prison.
Okay.
And the CO, or the correctional officers there, keep blocking my way, right? And they block my way by saying, you know, oh, what are you, a 5%er? You know, keep your half-breed behind out of here, etc. Right? So there's both anti-mixing, anti-Muslim identity, and also anti-blackness, because all of it gets called the N-word, all of it gets all pulled in together. Right? But this same CO is lumping this inmate with all the other black or unhyphenated black people. Right? Let's put it that way. And so, yes, there's a way in which the religious affiliation comes in, but in my view, it's because that racial affiliation is being racialized. Right? Meaning, the idea is that there's not so much problem with, like, you know, who you pray to. Right? But what they have a problem is this idea of, oh, this is a black way of thinking spiritually, right, about your own inner spiritual life.
Yes.
Right? And the pejorative idea about being a 5%er, etc. Talk about being a savvy CO. But anyway, it is, in my view, very much enmeshed in this idea of a racial project. You know, that it's still very much about racialization, and not purely, you know, hearing that, you know, the idea about anti-Muslim bias, you would think, okay, then it's just about religious affiliation. Right. And I don't think it can be disentangled so much.
No, I don't think that it can be disentangled either. I think that it's not going to be disentangled because the matters that affect the unhyphenated black community are also that of internalized racism or self-hatred in many regards, and more so towards like an emotional, issue with self versus how they're commonly perceived. But like still, even in the same capacity of being like grouped into unhyphenated black people, there are cases that are, like, say for example in South Carolina, where there's, I'm not sure if you're familiar with the Sundry Free Moors Act, but there were four, like well before, right at around the time of the birth of the United States as a nation, as a developing nation, there were 4 citizens or subjects to the Emperor of Morocco who were captured, and taken as prisoner on their way to another place. And so instead of being taken to where they were supposed to be taken and presented to the emperor and placed under his protection, they were taken to South Carolina and then wrapped into the American or the United States institution of slavery in the South at that time. What they ended up doing is they eventually, through emancipation or through indentured servitude, purchased their freedom and petitioned the court of South Carolina on how it would be, or how they would be identified or classified should they be put under detainment or incarceration, in which the state holds still to this day that they would be considered subjects of the Emperor of Morocco at that time. So, like, still within, and also there's also another case actually with Abraham Lincoln, where in 1855, Joseph Spencer versus William Dungy, he also known as Black Bill, which predates the Dred Scott decision, is also another case affecting the appearance of being more or less stereotyped and phenotypically stereotyped based on one's complexion versus on how they would identify. So the identification issue goes back even to 1855, before the emancipation of slavery. So, which was more or less like my question in regards to whether or not, well, based on Dred Scott decision, which still more or less holds true, which says that blacks or African Americans cannot, nor shall they ever be considered citizens of the United States of America. Which brings me to the question of the 5th and the 14th Amendment, which is rights to due process and equal protection under the law. But if blacks are not being considered citizens of the United States, here's the question of inclusiveness in regards to multi-race identification, because many blacks are engaging in this day and age identification through genetic analysis. So some blacks or Africans in America are identifying themselves as being genetically native to another landmass, as well as still also holding allegiance to the United States, which also still brings into, in my mind, still other issues of immigration and nationality. Because if these individuals are still, by supreme constitutional law being held as non-citizens, do they file for suits or for justice as being citizens or non-citizen nationals of the United States? So, and that still encompasses or still surrounds the issue of being or self-identification towards multi-racism.
That is fascinating. I didn't do any kind of sort of historical dive because my aim was to sort of respond directly to this claim that post-Loving v. Virginia, that a post-Loving v. Virginia generation now experiences discrimination differently. Right. So it's historical in the sense that I'm picking up from the 1970s, from that moment. But obviously it's much richer and deeper than any of that. Good project for you, maybe. I don't have to be here by myself doing the work, but it's part about being public intellectual. We do a production of knowledge together, right?
He's an author as well.
Well, thank you very much. I greatly appreciate your response.
I'm so happy someone's